Yes.
Good morning, Chairperson, Commissioners, and colleagues. My name is Mpofu. I represent former President Jacob Zuma, together with my learned friends, Mr. Buthelezi and Ms. Siwunu.
Good morning. We represent the Kalata Group. I'm here with my learned friend, Khampepe, instructed by Wednesday.
Thank you, Mr. Van.
Good morning. My name is Nyoko Muvangwa. I represent the former President Thabo Mbeki. I'm instructed by Bokwana Burns. I appear together with my learned friends, Ms. Sokela and Dr. K. Moyo.
Can I request that you give me the spelling of your surname?
Of my one?
Yes.
It's M-U-V-A-N-G-U-A.
Muvangwa. Am I correct?
Yeah, that's correct.
Muvangwa.
That's correct.
Thank you.
I must apologize. I omitted to mention that I also appear on behalf of the former cabinet ministers who are documented
Yes.
in the papers.
Thank you, Ms. Muvangwa.
Morning, Chairperson, Commissioners. I will be presenting evidence on behalf of the evidence leaders today, Chairperson.
And your name?
Oh, sorry, it's Vassoni.
Thank you. I intend to allocate 30 minutes to each counsel for the main argument and 15 minutes for the reply.
Thank you.
Mr. Mpofu?
Yes, thank you, Chairperson.
The ball is in your court, sir.
Yes. Thank you very much, Chairperson. Yes, what I will then do is, all right, I'm going to sequence the argument slightly differently to what I had planned, given the amount of time allocated. Chairperson and Commissioners, this is a recusal application brought by the former President. It has always been said that a party that brings a recusal application has a very unenviable task, and that according to our courts, the motives of such a party should not be lightly questioned. This application is particularly in that realm because, firstly, from a public point of view, it involves very serious matters involving the TRC and part of our history, which is really forms part of the DNA of this country. But also it involves very senior former presidents, very senior judicial officers, and very senior practitioners. For me personally, it involves my real learned friend, Mr. Asmenya, and other people that I consider to be brothers and sisters. But enough of the sentimental stuff, we have to get on with the job. The application is based on 3 grounds on its merits. And those are, as we've spelled out in our heads, we've rolled up the grounds that, if you count them mechanically, you'll find 5 separate grounds, but they can be rolled into 3, and that even includes the overlapping grounds in the Mbeki application. But before I deal with those, with the permission of the Commission, I would like to deal with the preliminary points that have been raised reciprocally by both sides. The one preliminary point raised by us and in the Mbeki application as well is the competency, authority, and status, if you like, of the answering affidavit, to the extent that it was deposed to by Advocate Semenya, who is the chief evidence leader. The second such preliminary point is raised by the other side, and for shorthand, let's call it undue stroke unreasonable delay. And it is argued that the so-called undue and unreasonable delay is a complete bar and necessitates the dismissal of the application up front. Needless to say, our position is that the preliminary point raised by us should be upheld, and the one raised by the evidence leaders dismissed. For the following reasons. In respect of our preliminary point, it is trite that a party that deposes to an affidavit on behalf of another should be properly authorized to do so, number one. The other very trite, or even more trite, rule is that when such authority is challenged, then the party that, whose authority is challenged attracts a duty to then prove that authority. In this case, we raised that objection in the answering affidavit, and until today there's been no response. No affidavit, no nothing, basically, to gainsay the challenge to authority. That alone should be fatal to on this issue. But putting aside the non-response, the issue is based on the following grounds. Firstly, you would have noticed that in the application, the cited respondent is the chairperson of this commission. But the answering affidavit, so-called, purports to have been done on behalf of the commission. Even if it was done on the commission, our view is that our submission is that the commission is not per se the respondent. But let's assume for argument's sake that it was. Then there would still have to have been an act of granting authority to the deponent, which is sadly lacking in this matter. It is again tried that where authority is challenged, if it's a juristic person, then the party produces a resolution or whatever it is. Or if it's a human person, then they produce a confirmatory affidavit from such person. None of that has been done. The second,
we would have liked to see something like a resolution, Sisi Khampepe hereby resolve to authorize Ismail Semenya SC to depose to the affidavit on behalf of myself and or the commission. That's what you have wanted to see. What did you want to see?
No. The chairperson is not a juristic person. I said if it's a juristic person, that means an inhuman agent, then you produce a resolution because a company doesn't have life. But if it's a human person, then you produce a confirmatory affidavit. That's what happens every day in our courts. But in any event, the challenge must be met. That's the whole point. Here, we don't have to go into whether it's a resolution or whatever. The challenge has simply not been met with any response. The second ground upon which we base this is that my learned friend, Mr. Semenya, says in the relevant paragraph that he has an interest in this matter. And then in the heads he says he's a witness, effectively. And in the same breath he says he gave legal advice. You can't do that. If you have an interest in the matter and you are a witness, then my learned friend would know better than me, then you are precluded from also rendering legal advice in that same matter, let alone to act on behalf of the respondent. The last ground is that Mr. Semenya, to the extent that he is indeed a witness, is for that reason, and the one that I've just mentioned, a witness in the matter, and therefore conflicted. On that basis, then, what that means in reality is that the application is unopposed. Because if the answering affidavit is incompetent for whatever reason, then it must be read as pro non scriptura. But assuming that the Commission will find that despite all those defects, the affidavit is competent, then I move to the next, to the preliminary ground that is raised by them. And it goes like this. The Commission was appointed in May, I think, and then the application was brought in December, therefore there was a 6 months delay, something along those lines. Well, firstly, the factual basis of that objection is false, in the sense that it is said that the former presidents ought to have known that the Commission was appointed in May or whenever it was. There's no legal basis that is pleaded as to why they attract that duty, or why they attract it more than any other South African, because there was no notification given to them. There's no constructive knowledge that can be attributed to them. Obviously, it should be obvious to everyone that the first time, at least former President Zuma, got wind of the fact that this Commission implicates him or needs evidence from him or whatever, was when the Rule 33 notice was granted. So that's really the starting point. The starting point can never be made. It must be the time of the Rule 33 notices. Speaking specifically for former President Zuma, he wrote, through his attorneys, Mr. Kwinana, he wrote a letter to this commission, to the secretary of this commission, stating that he was overseas. I'm paraphrasing, it's Annex B to the founding affidavit. He was overseas, he had not had time to consult with anyone. He would attend to the matter and get legal advice, words to that effect. So again, how can he, when he had not even seen the documents or engaged or consulted with anyone, how can he be faulted for not taking steps at that stage? Then, of course, the main ground raised by former President Zuma, namely the alleged misconduct and conflict of interest on the part of the chairperson and Mr. Semenya. That ground obviously arose only upon in the last couple of weeks before the commission was given. And to be fair to the evidence leaders, they don't raise the point that on that particular ground it should have been brought earlier than when it was brought, which was, as I say, within a couple of weeks. So even if the so-called unreasonable delay ground was good, which it is not, it would obviously not be, it would not defeat the entire application, particularly the main ground raised by former President Zuma. But in terms of the law as well, and I'm not going to belabor this because we've dealt with it in the heads. There's no law that says that unreasonable delay is a complete bar in recusal applications. It may be a complete bar in terms of reviews, given the 180-day rule in so-called unreasonable period in terms of legality. But there's no authority that I know of or that can even exist that says undue or unreasonable delay is a bar. And that is known. I don't have to say that I'm preaching to the converted, because this commission dealt with this in November. When the Semenya SC recusal application was raised here, the objection was undue delay. And this commission dealt with the matter, and at the end of its ruling, it said, well, the delay was undue, we deprecate that. That was it. In other words, even when the undue delay was found to exist, it was never seen by this commission to be a bar. So it cannot start now to be a bar. So much for the undue delay. Now, coming to the merits of the recusal grounds, assuming again that the affidavit is regarded as authorized. This is what I propose to do. That's the adjustment I was referring to save time, because the time is quite short. The main ground raised by former President Zuma is the one that relates to the alleged misconduct by us in the form of giving advice to the evidence leader on how to succeed in the Semenya SC recusal application. The second ground is the ground which, again, for shorthand, I'll call the occupational history ground. And that's the ground that deals with the fact that the chairperson was previously employed by the Truth and Reconciliation Commission, its Amnesty Committee, and the NPA as the deputy NDPP. Now, then the third ground in the Zuma application is, of course, the utterances, attitude, hostility, vengefulness, hatefulness, all those that are pleaded in the founding affidavit associated with the detention without trial of former President Jacob Zuma. So this is how I propose to deal with the matters. And I want to be understood very clearly on this point. The third ground that I've mentioned, that's the Constitutional Court ground, is, if you like, is the alternative ground. If you go to the notice of motion, which you'll find, our notice of application, which you'll find on page 2 of bundle A, you'll see that I think prayer 2 says is for the total recusal of the chairperson, and prayer 3 is for the partial recusal, if you like, only in respect of former President Zuma. So that ground is an alternative ground by any description, in the sense that it only talks to prayer 3. If it succeeds, put it this way, if only that ground succeeds, then obviously the chairperson would not recuse herself in total. She would recuse herself partially, quote unquote, in respect of him. So because there's no time, we can pack that ground. We're not abandoning it, but we're packing it because I want to highlight what I call the main ground. The second ground, other than the one that I'm going to deal with, is the one of the occupational history. Now that ground for us is And one can argue these things in any sequence. I'm just trying to give a logical sequence. The second ground that I want to deal with is the occupational history ground. I'm not going to dwell much on that ground for two reasons. One, it is the main ground as far as in the Mbeki application. So I'm anticipating that my learned friends from President Mbeki will speak extensively on it. Two, our submissions have been extensively put in our heads and in the founding affidavit, and all of them must be taken as read. But three, most importantly, as a matter of law, our ground, main ground, which I'm going to talk about now, is based on actual bias. And former President Mbeki's grounds are based on a reasonably apprehended bias. Now, as a matter of simple logic, if the ground on actual bias is upheld, then one doesn't have to bother about reasonably apprehended bias at all. I don't think I need to motivate that. So, as a result, for the reasons, three reasons that I've just mentioned, again, that second ground, as far as we're concerned, is persisted with, full blast. But for the purposes of oral argument, I will simply refer to it at the end, to the extent that I will still have time. Otherwise, we'll deal with it in reply. So everything we've said in the affidavits and the heads must be taken as read. So that then leaves me with the main ground raised by former President Zuma, which is the actual bias ground. That ground, as I say, is fatal to, if it's upheld, it's fatal to the entire case. Then there would be no need to deal with the other two. Well, there might be a need to deal with them to the extent that the matter might go further than this. But for the purposes of the decision today, there'll be no need to deal with them. Why do I say that? One of the fallacies that appear from the papers of the evidence leaders is to conflate is an understatement, but to mix up the test. The test for bias, the test for reasonably apprehended bias must never be conflated with the test for actual bias. So, a simple example to demonstrate this is that we know that there's the so-called double reasonableness test, which comes from Sarfu, Sakau, and that line of cases. It should be obvious to anybody that that test only applies to reasonably apprehended bias, not to actual bias. Why? Because when you talk about double reasonableness, you are already talking about the reasonable person. In other words, you're talking about the objective test. But actual bias has got nothing to do with that. You can't say someone is actually biased because a reasonable person will think that they are biased. That's just terminological, not even an oxymoron, but it's senseless. So the court, or rather this forum, would then be spared if there is a finding of actual bias. It doesn't have to go into the double reasonableness test. Similarly, another test which they invoke is the presumption of impartiality. Again, the presumption of impartiality cannot apply in this situation, because here, although the chairperson who is being asked to be recused is judicially trained and held very high and esteemed offices in the judiciary, she is not being asked to be recused as a judicial officer, per se. She's being asked to recuse herself as a chairperson of an administrative body. So it cannot be that if, let's say, this was the recusal of Archbishop Tutu in the TRC, because he was not judicially trained, a separate test would have to be applied. But simply because the chairperson here happens to be someone who's judicially trained, then the test is different. That's also legal confusion. So, and let me put it very simply. A judge, qua judge, is never appointed by the president in the way that a chairperson of an administrative tribunal is, number one. Number two, when a person is sitting as a chairperson of a tribunal, they are, as it is said in the heads of argument of the other side, they are, in a way, they are subservient to the person who appointed them. That's why it's said that they can only make recommendations. They can't act. The only person who can act is the president. Unlike a judge, when a judge issues an order, he or she doesn't depend on the whims of anybody to do so. So there's a vast difference between someone sitting as a judicial officer and somebody who happens to be a judge sitting as the head of an administrative body. With the greatest respect, a person sitting, chairing an administrative body appointed by the president is in no better position than an advisor to the president. In fact, that's what they do. They advise the president or make recommendations to him. They are in no better position to a director general who may make suggestions to the principal.
But the recommendation is based on finding. Now, where does the whim come in, or the influence? The chairperson would make a decision, fact-based, and not on the whim of the president who appointed.
Yes. No, Justice Khampepe, I think maybe either you didn't hear properly or I misspoke. If I did, I apologize. The whim is not at the level of the finding. You're quite right. The decision maker, any decision maker, whether it's Archbishop Tutu or whoever it is, makes a finding. That you can put aside. The whim comes like this, and this is trite as well. Once an administrative body makes recommendations to the president can literally take that thing and put it in the dustbin. Okay? That's where the whim is. When it's a court order, he can't do that. So that's the difference here. So that's, if I put it the way you're putting it, then I misspoke. Yeah. So the whim comes on the end of the implementation. And that is why, if you will remember that one of the defenses raised in this matter is exactly that this commission only makes recommendations, and it's correct. So that's where the whim is. Now, that, by the way, is another defense which has short legs, which doesn't carry any water, because it's related to the defense that says the commission is inquisitorial and not adversarial. That defense cannot go anywhere. It should die before even arrival. Because yes, of course, the commission itself, in terms of its terms of reference, carries its work inquisitorially. But this is a sui generis application, the recusal application, as was the Semenya recusal application for that matter. And the recusal application is clearly adversarial. So the fact that the commission itself might be inquisitorial is neither here nor there. And to the extent that it is adversarial, it is improper conduct for the chairperson to give advice to one of the adversaries. Plain and simple. If the matter is adversarial, as it obviously is, then the rule that applies is the one that was enunciated in the SCA in S versus Roberts, 1999 4 SA 915 SCA at paragraph 23, that you'll find in the preamble to our heads. And it says as follows, it's very simple. That justice publicly be seen to be done necessitates as an elementary requirement to avoid the appearance that justice is being administered in secret. That the presiding judicial officer should have no communication whatever with either party except in the presence of the other. Now, this is what we call an a fortiori case. So even when that person who's sitting there is chairing an administrative body or even a DC, for that matter, at work, that they can advise the employer or the employee in that particular adversarial setting is plainly, one doesn't have to be a lawyer to understand that there's something rotten and wrong with that. So this principle is quite clear.
But you did not bring out the content of the advice. It's just advice in vacuum, the expression advice. The content of the advice,
yeah.
The text of the advice.
Yeah, the content of the, yes, that's one of the defenses. That's wrong, plainly wrong. Because if you go to paragraph 38 of the founding affidavit, and you'll find that in bundle A, sorry. And maybe let me start by explaining the following. The content of the advice, Justice Homer, is specified in the paragraph 38, 39, and 40, which I'm going to read out to you now. Well, one of the things we're told is that we don't say the place, the time, and what the issue you are raising, the content. It's not true. As far as the time is concerned, this is what 38 says. In the build-up to the hearing of the Seminya recusal application, so that's the timing. It was in the, it's not the date, but we situate when it was. Justice Khampepe, as a member of the judiciary and as a decision maker who would ultimately make a final ruling, conducted herself improperly and exhibited actual bias in favor of the non-recusal of Advocate Zuma. And here's the important part. A good example, or shall we say evidence of this, is that Justice Khampepe, without the knowledge of the applicants, privately and secretly gave advice to Advocate Seminya SC on certain key weaknesses in his case, that's the content of the advice, and even advised him on what to look out for and what to convey to his legal representative, Advocate Vasoni SC, in order to succeed in the recusal. That's the content of the advice. This is a case of plain and gross misconduct, irrespective of the merits or demerits of the Seminya recusal application. Then we say at 40, purely in order not to jeopardize ongoing investigation into this serious conduct, which poses a threat to democracy, I deliberately and consciously refrain at this stage from revealing the complete, underline complete, evidence available to me. If the accusation is denied, then I will be left with no option but to resort to alternative procedural mechanisms in order to secure or provide the evidence. I trust that this will not be necessary. So this is what happens here. Surely, but surely, it should be sufficient. If you allege that advice was given One, to advise the person on how to succeed, and secondly, to advise him on what to look out for to convey to his legal representative, Advocate Vasoni. Those are specifics, allegations. How can it be said that the content is not given? Whether that at that point the advice was change this paragraph or that paragraph or look up this case or that case is neither here nor there. The misconduct is in the giving of the advice without the knowledge of the other side. That's where Roberts puts emphasis. There's nowhere in what I read from Roberts that says the judicial adversarial, it says should have no communication whatever, right? So whether the communication is X, Y, or Z, doesn't matter. It should have no communication whatever with either party except in the presence of the other. That's the gist of the... It's not even this red herring thing about whether it was secret or whether it was done, whatever. The point is the non-disclosure to the other side of such communication. It's not done. Everybody knows that. Again, one doesn't need to have an LLB to know that a decision maker cannot advise one of the adversaries about anything. It doesn't matter whether it's about a big thing or a small thing or a medium thing. So that's the gist of the attack. And to the extent, to anticipate what my learned friends will say on this, to the extent that, yes, for reasons that I explained here and in the replying affidavit, some of the evidence, because of what is put in the as ongoing investigations, because some of that evidence might not be complete, that's why I put the emphasis on the word complete. Well, so be it. It's not presented. But that's not the test of how you test evidence. There's something in law of evidence called the sufficiency of evidence or the cogency of evidence. So to make a blatant example, if I have evidence that somebody has stolen bread from a store, I can at that stage lay a charge against them for that. The fact that it might turn out later that they also stole eggs and they also stole milk and what have you, well, the point is the evidence that's presented at that time sufficient at that time to establish that which I'm accusing the person of? And in our respectful submission, this evidence that is here is sufficient. We agree with our learned friends. They say in the answering affidavit, well, if you don't give us that further evidence, then your application must be dealt with on the basis of the allegations in the founding affidavit. We concede that. We can't expect the tribunal to make a finding with some withheld evidence. But the point is that on the evidence that has been presented in the founding affidavit, there is sufficient for allege, or not allege, to establish as a matter of fact that the rule in S versus Roberts was breached. And that's enough.
Yes, you've made your point.
Yes, thank you, Justice Hong. Now, if that, assume now, I mean, there might be engagements on all of this, but for now, I beg the panel to assume that we're correct on those facts. In fact, the reason why you must assume that we're correct is because there is nowhere in these papers where the giving of the advice, which is the gist, is denied. Nowhere. We're given a diversionary story about the only defense actually is that, no, the evidence leaders and the commissioners have frequent interactions. The answer is, so what? Who has disputed that evidence leaders and commissioners have frequent interactions? So it's not the interaction per se, it's the fact that this was an improper communication. Nobody in their right mind will say, evidence leaders must not talk to commissioners about the weather or about the matters to do with the terms of reference. But once there is a specific recusal application for a particular purpose, and the commission and the chairperson sends an email that says, please watch out for paragraph 45 or this and that, which is also there in the affidavit, or do this research or whatever, then that's just wrong. I mean, honestly, I shouldn't be standing here explaining that is an affront to the Constitution and an affront to the oath of office, to the extent that it is relevant, of any office for that matter. Sorry. Right. Now, the point is this. In the absence, and my learned friends, again, to their credit, they say in paragraph 6, a proper consideration of the affidavits of their heads that have been filed suggests that, save for the allegations made by former President Zuma of improper interactions, and I'll come to that, and Siminya SC, for the most part, the applicable facts are not, in essence, in dispute. That is true, except that the exception that they carve out also doesn't apply. What has been pleaded here, in plain and simple terms, Civil Procedure 101, is what is called confession and avoidance. Now, confession and avoidance means this. You say, yes, the advice was given, or I don't dispute that the advice was given. But, as they say, there's nothing wrong with it because commissioners speak to evidence leaders all the time. But that's what is called a non sequitur, because the fact that evidence leaders, we all know, my learned friend Mr. Siminya and I have been in many commissions together. We know that happens. But that's not the point. That's diversion. It's called a straw man defense. You create your own case and then you fight that case. That's their case. Our case is simple. It's got nothing to do with the frequency of interactions or non-frequency of interactions. It is that in this particular interaction was improper, illegal, and against anything that any decision maker should do. Now,
if I may, you're eating into your time.
Pardon?
I say you have eaten into your time. You have eaten into your 30 minutes. Carry on.
Okay. Thank you.
It's just a friendly reminder.
Yes. No. Thank you. I take it as such. So, the point really being made, and I have to make this point. This is not a complaint about, at least not yet, about misconduct in the JSC sense of the word. Those proceedings, if they happen, and former President Zuma has said that he will institute them, will take their own course. Here, we're only dealing with a narrow issue of whether, assuming that the facts, the confession and avoidance is held to be admitted, because that's really what it is. Okay, let me go to basics. And this will be just the point preceding my last point, Justice Kom.
Mr. Mpofu?
Yes.
Your time has expired.
And that's what Justice Kom. Pardon? Wrap up, yes. Okay, thank you, Justice Khampepe. Now, I'm saying, in wrapping up, let me say this, because it's very important that these pleadings must be read for what they are. Confession and avoidance is described as follows. You say, I admit your facts, but even based on those facts, I'm giving you facts that countervail those facts, and therefore a different legal conclusion should be reached. You'll find that in Erasmus, I think it's Yeah, you'll find it in Erasmus. I don't have time to read it out now, but you'll find it at D1-22.8 under confession and avoidance. So you can't have, if you have a confession and avoidance, but you don't put countervailing facts, because the onus shifts in a confession and avoidance. Once you admit, you then have the onus as the admitter to put those countervailing facts. That's known as the Mabaso principle. If you fail to do so, then all we're left is the confession without an avoidance. So the confession is otherwise known as an admission. So those facts are admitted. Secondly, and lastly, and I'm indebted for the indulgence. This principle of failing to deal with such a serious accusation has been dealt with in our courts many, many times. It has been said in old cases, there's a case, just the name just escapes me now, a case, I think it was in the 20s or 30s, where it was found that if somebody makes a serious allegation against you and then you do nothing, you just look down, that is as good as an admission. That has been qualified by the SCA in subsequent cases. But the point I'm making is simply this. Faced with such serious accusations as I've read out, the absence of a denial or any explanation surely means that those facts are common cause. And none other than Justice Khampepe made that point in the case of Public Protector versus South African Reserve Bank, or the so-called CX case. She said at paragraph 190, the Public Protector's failure to deal pertinently and responsibly with the serious accusations made against her impartiality in light of these meetings that she had allegedly had with the President, meant that the High Court was left with only the handwritten notes as evidence of what was discussed at the meeting and no countervailing account from the Public Protector. This led the High Court to conclude that, quote, the question remains unanswered as to why the Public Protector acted in such a secretive manner, and she does not give an explanation for doing so. That is good law, and to the extent that it is good law and it is authority of the Constitutional Court, it must apply here. Because Justice Khampepe was quite correct. When somebody faces a serious accusation against her impartiality, the least you can expect is that they will give an explanation. And if absent that explanation, with the kind of wishy-washy version that we've been given in the answering affidavit, so-called, then the accusation remains unanswered. And if it remains unanswered, the chairperson must recuse herself on that basis alone. Firstly, for giving the advice, for having the communication undisclosed, and for having it in the absence of the other party in these kinds of proceedings. And for the last parting shot is that in the Pinochet case, the famous Pinochet case, the issue of non-disclosure, which really is the nub of this, not the secretive what, the issue of non-disclosure was held in that case as decisive. And I am aware, before somebody reminds me, that that case was decided on the basis of a reasonable apprehension of bias. But everyone knows that actual bias, the alternative to actual bias, if the tribunal doesn't find actual bias, then of course the reasonable apprehension, such as was the case in Pinochet, is sufficient. Because I've run out of time, I will, as I said, defer on the question of the occupational history. I will defer on the question of the occupational history to the Mbeki team, but as I say, I stand by whatever is in our papers so that I'm not deprived of dealing with that matter in reply, should it be necessary. I'm indebted for this.
There's just one aspect that
yes.
My learned colleague would like to deal with you.
Yes.
Thank you.
The first one is It's just for my own understanding. In the paragraph 15 of Mr. Zuma's affidavit, he refers
Founding. The founding.
I can just, you can just listen, but it's paragraph 15. You refer to the commission that had to locate the DSO, the Scorpions, chaired by Judge Khampepe as the Commission of Inquiry. But at 17, the commission chaired by Chief Justice Raymond Zondo, you say the so-called commission. I don't know why the distinction and what does that imply, so-called commission?
No. Well, firstly, I don't know if you are reading the same paragraph 17. There's no so-called commission there. It says, I was required to appear before the so-called Zondo Commission. So the so-called is not about the commission. It's about the fact that it's colloquially known as the Zondo Commission. But the name of the commission is, it's called the Commission into Allegations of State Capture, Corruption and Fraud in the Public Sector, including organs of state. And everyone, to avoid that long thing, called it the Zondo Commission. So that's why it's called the so-called Zondo Commission. I don't know.
But the other one was not so.
It was.
Okay, but you don't see that. But let's go to paragraph 52 of the statement. Can you just read it? Because my understanding seems to be that if Justice Khampepe does not recuse herself, or perhaps if the finding is that she does not recuse herself, then Mr. Zuma is out of here, is not participating. Can you just read that and speak to it briefly?
Well, okay, before I even read it, that conclusion is not correct, but let's read it. It says, last but not least, the previous conduct of the chairperson in relation to my controversial detention without trial and the subsequent negative public commentary make it untenable for me to comply with the request to participate in the present commission as set out in Rule 3.3 notice sent to me by the commission, and in any process which is tainted by her demonstrable and or reasonably perceived bias. For ease of reference, refer to the notice. No, you're reading that paragraph wrong. That paragraph is very simply says that and it goes to what I call the alternative, the narrow recusal, which would pertain only to former President Zuma, and has nothing to do with former President Mbeki. All that paragraph says is that it motivates why it is, it's the same as saying, if there's a judge who took a bribe, and I'm aware that the judge took a bribe, it's untenable for me to be expected to carry on in front of that judge. And it's that simple. And that's all he's saying. He's saying, given what he calls, tainted by demonstrable and or reasonably perceived bias, then it would be untenable. Now, of course, that does not suggest anything about out of here. All it suggests, in fact, let me put it plainly, is that should this commission find that this ground, serious as it is not sufficient, and the chairperson should nevertheless continue having given advice to Advocate, to my learned friend Advocate Siminya SC, then former President Zuma will exercise his options which are provided in the Constitution. One of them he has already mentioned, that he's going to approach the Judicial Service Commission. The other one, which is obvious, is that he could approach the courts. So that's what that paragraph is meant to convey. Nothing more, nothing less. And as I say, any one of us, any human being, would find it untenable to appear under such circumstances. If I may just say one word about the Kalata Group. Of course, our papers cover and our heads also cover the statements made in the Kalata Group. But for the record, it must be said here and now, plainly, that nothing in this application is meant to take anything away from the validity and the concerns of the Kalata Group, or to divert the serious work of prosecuting murderers who are responsible for vile apartheid atrocities. But the fact, if that process, important as it is for this country, is done before a tainted commission, then that is what will delay for another 10, 20 years the process which is so important for this country. So nobody must ever walk away from here. They must disabuse their minds from one, that there's a need, or rather a desire to delay this process, other than to cure its imperfections and its taint of bias. Thank you.
Thank you, Mr. Mpofu.
Sorry.
Maybe I would probably not expect the chair to say that, but she could if she wished. There's some strong language used by Mr. Zuma that the chair harbors deep-seated hatred and animosity
Yes.
towards him.
Yes.
And another strong word is that she acted with malice. All these words are
Yes.
very strong, and it seems it emanates from the judgments that she penned. As I look through the papers, at least speaking for myself, that is my impression.
Yes.
The need for those choice of words, if the chair acted or penned a judgment, a majority judgment, is there justification for that?
Look, the Justice Homo, I don't know. I'm not the one who was sitting in a cell detained without trial. So if...
I'm not talking about that. I'm not talking about
No, but that's what this point is about. This point, I thought we are dealing with the third leg. That's what it is about. The point about the judgments in the Constitutional Court have to do with the detention of their trial, unless maybe I'm on another page.
Carry on.
Yes. So, being not the person on whom the shoe pinched, I cannot speak for the deponent use of...
Of course you can speak.
Well, if I can just
because
finish.
your counsel, from 1958 in the Matonsi case, you lead the ship, and if there are things that you know cannot be backed up, even in the rules, LPC rules, you're not supposed to press that aspect.
Yeah. No, that of course is true. But if you allow me to finish, then I will develop the point. Firstly, that rule applies to all of us. So, Mr. Smenya's affidavit says the application for the recusal of the chairperson is spurious, vexatious, scurrilous, and even malevolent. That's equally strong language, to use the adjective that you used. Now, the point of the matter is that we should assume again that when Mr. Semenya makes this, he's not making them for himself. Those are the views of the chairperson, presumably. And therefore, the strong language used on both sides must be looked at in its proper context. What President Zuma says, Justice Home, is that he doesn't just say you must read the judgments, as you say. He says the tone, which was, and the posture, which was adopted in sending him to jail without a trial, the first of its kind in the new South African.
Without a trial or hearing?
Without a trial. Trial. Section 35(3), right to a fair trial. That right to a fair trial, which is the right to say I'm guilty or not guilty, the right to appeal, or the right to mitigate. Section 35(3) of the Constitution. All those rights to a fair trial were negated. So that's a fact. Now, the number one. Number two, he says on top of the tone, something which is, I don't want to suggest the evidence, any ill will on the part of the evidence leaders. But you must read their answering affidavit and read their heads.
Yeah, but Mr. Mpofu, you are standing there. The evidence leaders have not come yet. We are on that aspect.
Yes. So I have not even made the point I'm going to make. I mustn't make the point?
Maybe no.
Thank you. No, the evidence leader, the point I was making is that, yes, the evidence leaders have not said a word, not one word, breathed one word about the allegation in the founding affidavit that Justice Khampepe conducted a publicity campaign on why former President Zuma was convicted without trial. She went and had an interview with Olim Gambi of Newsroom Africa, and another one with a Karen Mon of News 24. That is not done, right? So a person who has been subjected to all those things, detention without trial, an uncharacteristic publicity campaign about a case, sorry, Justice Home. Just 1 second, please. All I'm saying is that it should be understandable. It might not. The tribunal will take its own view that why someone would use such language, which, in my respectful submission, is probably more measured than the true feelings of former President Zuma. But Article 13 of the Judicial Code states that a judge must, Article 11, save in the discharge of judicial office, a judge must not comment publicly on the merits of any case pending before or determined by that judge or any other court. Not enter into a public debate. A judge must not enter into public debate about the case irrespective of criticism leveled against the judge, the judgment, or any other aspect of the case. Both of those rules were breached in a superlative way when those interviews were done. So how would you feel? And I'm not asking you to answer, it's a rhetorical question, Justice Home. How would one feel that somebody not only takes you to jail without trial, but goes on forever justifying it in the public domain in breach of the judicial code of practice? Would you give them a hug? No. You will feel strongly about it, and if those strong feelings are reflected in the affidavit of former President Jacob Zuma, then so be it.
Yes, you have made your point. Thank you.
I'm indebted to you.
Thank you. Ms. Muvangwa.
Yes, thank you. As it pleases the Commission,
Chair, I don't know whether we should not anticipate the tea break so that we don't interrupt the submissions of